Welcome back to Winning Isn't Easy. So let's talk about whether the, in quote, new ERISA regulations have transformed the way that a disability carrier or plan will handle a disability insurance claim. Now, the new ERISA regulations that govern long-term disability insurance claims went into effect April 1st, 2018. And here we are in 2023, still calling them new ERISA regulations. So while these new ERISA regulations provided much needed protection to disability carrier policyholders or plan beneficiary, after years, 5 years of enactment, I find that there is still disability carrier conduct that is causing delay and denials. So let's first talk about the impartiality of the claims process. The regulations prohibit anyone allegedly involved in the claims process, such as a claims adjuster, a peer review doctor, or a vocational evaluator, from being incentivized to deny the claim. Now, back in the day, disability carriers like Unum would reward their claims examiners with pizza parties and other goodies, if you will, for denying claims. If they met a certain threshold of claim denials, they got a bonus or they got a little party. The disability benefit determination is supposed to be independent and impartial. So in other words, this is kind of supposed to be walled off. But in my law office, I continue to see lots of disturbing trends in violation of these ERISA regulations. And one of them is where the liar for hire peer review provider, who was the basis of you will, of the first denial, who criticized and cherry-picked and even rejected the treating provider's opinions, is on appeal re-reviewing the medical evidence submitted when the denied policyholder or plan beneficiary appeals the wrongful denial. So you're sending this case back to the fox, if you will, for a second chance at eating the chickens. The question becomes, does the carrier really expect that the peer provider who gave the carrier the ammunition with which to justify its first denial is going to change their mind about the medical evidence on appeal? Now, the peer review provider is generally an internal physician or a physician on contract with the carrier or the plan, or is employed by a third-party company that supplies medical reviewers. Everybody in this whole process knows where their bread is buttered. The fox is not only watching the hen house, the fox is having breakfast, lunch, and dinner on the chickens. So I don't think that having the same peer review provider review the medical records on appeal is consistent with the regulations. Now, the regulations also talk about consideration of a favorable Social Security decision. The U.S. Supreme Court in ERISA regulations require that a disability insurance carrier plan consider a favorable Social Security decision. And the carrier is supposed to explain why it disagrees with that favorable Social Security decision in upholding its claims denial or denying the claim. What the reality is that many disability insurance carriers or plans don't even ask for a copy of the Social Security file to review the basis of the Social Security decision. If they ask for it, they don't even wait to get it before they make a decision. And then, of course, if they get it, they'll look at it and say, well, you didn't have all of the evidence that we now have. We had surveillance. We had our medical reviewers review this. We had social media posts. We had all sorts of stuff that the Social Security judge didn't have. Or that decision was so long ago, it's stale, it doesn't count, and they will reject the claim. But they will not necessarily have reviewed the claim. The other thing they'll do is they'll say, we have reviewed this. And according to the case law, we're going to discuss what we see here. And we have the right, of course, to accept it or reject it. And one of the reasons we're going to reject it is, we have more information. Our doctors disagree. But that Social Security disability award was based on the grids. And at step 5, people cannot be awarded benefits in part under the grids based on their age. If you don't grid out, then age is also a factor as you evaluate the ability to do other work in the mythical, not real world national economy in view of the policyholders or plan beneficiaries' age, education, transferable skills, and restrictions. So they're going to say it's a completely different standard of review. We don't take into consideration age. Social Security does, and so what? Too bad, so sad. We've considered it, but we're rejecting it. Now, there's also a mixed bag in that the new ERISA regulations will help ERISA disability policy holders in some respects, but practically it's a mixed bag because carriers are still playing games with the claims. So, as I said, they will have the liar for hire peer review doctor do the second review. They will send cherry-picked records to that liar for hire reviewer to render their opinion. They may not send all of your material to their liar for hire people. They still, in my experience, are incentivizing adjusters and other players in the disability world for denials. And of course, they'll play the Social Security disability decision game. These are just 3 of the things I see the carriers still doing, notwithstanding these new ERISA regulations. There is, however, some hope here in that I am also seeing some of the courts take a look at the disability carriers' failure to follow ERISA regulations, and in some egregious cases will actually say that the failure to follow those ERISA regulations changed the standard of review from arbitrary and capricious, which is the kiss of death, to de novo. So again, this is a factual analysis based on each one of these cases and how bad the courts may feel that the disability carrier plan's violations of the ERISA regulation is. Got it? Let's hope that the courts really start enforcing these regulations and put some teeth in them so that they really mean what they mean. And the carriers are held, their feet to the fire to meet the requirements of the ERISA regulations. And again, one of the hopes that is becoming a reality, as I said, is egregious violations are being found sufficient to change the standard of review. So if, for example, the disability carrier is not rendering a decision within the first 45 days and doesn't timely or give legitimate reasons for the request for an extension, the courts are saying, well, that 45 days was a hard stop. You violated the regulations. The standard of review changes. So there's hope. Let's just hope that the courts become more educated, if you will, about the games that disability carriers and plans are using to violate these ERISA regulations, which were in fact designed to help protect disabled disability carrier or disability policyholders and claims beneficiaries. Got it? I hope that you enjoyed this week's episode of Winning Isn't Easy. And I would love it if you would like our page, leave a review, share it with your friends, and subscribe to this podcast. That way you're going to get notification when a new episode comes out. Thanks for listening. Talk to you next week.
Have you been robbed of your peace of mind from your disability insurance carrier? You owe it to yourself to get a copy of Robbed of Your Peace of Mind, which provides you with everything you need to know about the long-term disability claim process. Request your free copy of the book at kvlaw.com today.